So let's start it. Can we call the meeting to start?
Yeah, of course. That's why we're all here.
Great. I'm looking forward to in the future meetings being more quiet so you guys can run this and I'll just take notes. So let's do this. We have welcome everybody. We have our 5 commissioners. Congratulations. Exciting. Isn't it great that we have Patience as our final commissioner selection? So yay. Welcome. And I was just telling if you have issues with WebEx, you guys have decided on using Zoom, we will have it next meeting. So that's just some housekeeping. You'll have some information.
Wonderful.
So yeah, so I'm sharing in my screen the agenda for today. Just a brief welcome, commissioners, reintroductions, a quick one, and then some trainings we're going to get from our city attorney's office, and then the decision-making points. So if there's any addition to the agenda that you may want to add right now.
So the only addition I have is, do we have a time to talk about meeting schedules?
Yes, thank you. I think we can do it at the very end or whenever you want to talk about it. Yes, meeting times. Would you want to start with that, or do you want to finish with it?
Well, it might, maybe if we do that as the first item under decision-making points, so that we can have a sense of how available everyone is in order to act quickly.
Yes. Great. I will take a note of this, make note of this. I'm going to start with some introductions. We have commissioners here. We also have city staff that will help us be here to guide us for some, if you have questions. So you'll see some folks and we have people from the public. Welcome everybody.
Yes. Sorry, one additional item. Do we have approval of previous meeting minutes?
Oh yes, where did that go? Oh, it's right here. Yes.
Oh, okay.
Yes. Oh, I'm sorry.
Okay. It is. Okay.
It's right there. Yes. We have it at the end. Yeah.
Got it.
I'm working on this is a PDF, so maybe I will. Yeah. Great. So with that, I'm gonna let you introduce yourselves quickly again, commissioners. We can start by alphabetical order by first name, and just to get acquainted, and I'll be right here taking notes.
Hi everyone, my name is Eliseo Juarez. I go by EJ. I am a commissioner on this body appointed by the City Council.
I think G is next. Greg Nichols, very happy to be here. I was appointed by Mayor Durkin. I don't know who's next.
I believe I am next.
An R, an S, and a P. Yeah.
Well, thank you. Hi, everyone. I am Patience Malaba. My pronouns are she, her, and I am the 5th commissioner who will be serving alongside commissioners on this body, and excited to be here.
I don't know. I think we're going by last name, so Rory.
Okay. I'll go next then. Yeah, Rory O'Sullivan, appointed by the City Council. Excited to be here, and looking forward to moving forward.
Hi, everybody. Nalima Shah. I'm one of the commissioners, and I was appointed by the mayor. Looking forward to getting to know you all.
Welcome, everybody. I'm Elsa Badrezboni. I'm the staff liaison, working for the Department of Neighborhoods, and I'll pass it on to, yeah, that's it. Logan over there. And after that, we have our city attorney staff who will be giving us our training. So if you are ready for this, we can start with the Open Public Meetings Act training that we've been looking forward to. So what can we do, not do, and what guidance we have to follow? So if you do you have all you need, Ariel and Gary?
The share button is still not lit up.
I think it's, I think I was made the meeting leader, so I have the share button. So Logan, do you mind transferring over to Gary? And then when it comes to the PRA stuff, transferring it back to me?
Oh, great. Will do.
So yeah, while he's doing that, I'll just introduce myself. Gary Smith, I'm in the government affairs section along with Ariel. And we advise, our section is kind of the point for advice for all city boards and commissions on compliance with general municipal law issues, including the Open Public Meetings Act and the Public Records Act. And as you've noticed, the OPMA, as we call the Open Public Meetings Act for shorthand, it does affect a lot of the work of a multi-member board or commission at the city and how the board or commission operates. So it is important that we provide a training on the Open Public Meetings Act, and it's also required under the Open Public Meetings Act that any member of a board or commission that is subject to the act does receive a training. So let me see if I can go ahead and share my screen here. This should work. So are you seeing this?
Yes.
Okay,
A little
great.
small, but yes.
Oh, let me see.
Try a slideshow.
Present, yeah. Okay. How's that?
Yep. Great.
Great. Hopefully I can advance screen somehow. Okay. Well, that first slide that you saw was just an intro screen. And this is, if you notice, this is a presentation that's actually prepared by the Washington Attorney General's office. And the reason for that is that I mentioned that training is required under the OPMA itself. And the AG's office is the public entity that is designated to provide a model training and provide trainings themselves. And so we just use the model training that the AG's office has put together. And that's the PowerPoint that we'll be going over today. And this is just a statement of the general principle, the general requirement of the OPMA that all meetings of the governing body of a public agency shall be open to the public and all persons allowed to attend. Governing body includes the city council as a multi-member governing body, but also any other multi-member boards or commissions that are created by the legal action of the city council and vested with decision-making authority. So there are many boards and commissions that are created by the city council that act in a purely advisory capacity. There's some question about whether the OPMA applies to them, but for the purposes of the Redistricting Commission, it's clearly established by the city charter, very clear decision-making authority, actually independent of the city council. So not much question that the OPMA applies. And that is the reason for the training today, and also just something to be aware of, because there are some pitfalls as far as OPMA compliance that I'll mention as we go through. But that is the general principle as stated in the Act. And so what is a governing body? It is, again, the multi-member board or other policy or rulemaking body, but also any subcommittee, any committee that is created by that governing body when the committee acts on behalf of the governing body. And that's interpreted as when the subcommittee itself exercises decision-making authority, or if the subcommittee were to conduct hearings or take testimony or public comment. So this already came up in the commission's work, where we were, I think one of the commissioners brought up the possibility of smaller committees working without noticing their meetings as public meetings. And that is allowable and is a very common procedure that is used by the city council or many other boards and commissions when they want to have a smaller group develop a policy or proposal with some without having to call a public meeting for all of their discussions. And so long as that subcommittee just functions as an advisory capacity and the larger commission retains ultimate decision-making authority, then that's fine. And it is a very common procedural tool that that a board or commission can use to conduct its business. And I didn't mention at the outset, but I can just see very small pictures of you. So if anybody has any questions, feel free to break in as I go through my slides here.
Hey,
So
Gary, actually, this is Nalima. So just so I understand that, it's the subcommittee, since in the subcommittee of the executive committee, no decision was made. That's why it's allowable. And then we came back to make the decision with the public meeting.
So that was, I think you're referring to when you selected the fifth commissioner?
Right.
Right, that was slightly different. That was when there is a justification for the larger body to go into a closed session termed an executive session for purposes that are outlined in the OPMA itself. And I'll talk a little bit more about that when we get to those slides. Slightly different context. In that context, though, you're right that the members of the public are not allowed to attend. But again, those are for specific purposes set out in the act itself, and I'll get into that in a little more detail. And this is kind of a busy slide here, but the general principle here is, what is a meeting? Meeting is kind of a circular definition in the act. It says that a meeting is any time that the governing body takes action. But action is defined very broadly under the OPMA to include any testimony, deliberations, discussions. So it's not just the final action of the board or commission on a certain topic that is required to be open to the public. Anytime that the board discusses or deliberates about board business, that is a meeting that is required to be open to the public. But the other important principle from this slide is that a meeting only occurs when a majority or a quorum of the board gather to discuss board business. So again, if a subcommittee of fewer than 5 were to meet and discuss a matter related to the board, not exercise any decision-making authority, bring it back to the larger board for a decision, then that subcommittee is not, because it is less than a quorum, less than a majority, and doesn't exercise decision-making authority, that the OPMA does not apply to that fewer number of commissioners. So, so all of this that I'm going to explain to you about the OPMA only applies when we have a majority or a quorum of the board engaging in a meeting. Another important principle to mention on this slide is that a meeting doesn't require the physical presence of board members. A meeting can also occur by phone trees, or by email. And that's probably the most common pitfall that we see boards and commissions deal with when conducting business, because it is very common to use email nowadays and to send collective emails. But if there is a collective discussion amongst a majority of board members via email, that does raise an issue under the OPMA and could be deemed a meeting that is not in compliance with the OPMA. So I think we've already mentioned this. I think we mentioned this at the outset, but it's just something to keep in mind. And you'll often see if we do distribute information, and staff can distribute information to the majority or the full board at one time, but we will often include a cautionary note that please do not reply all to this communication to avoid an OPMA issue. So that is a common pitfall. And I would also say that that is also applicable to the use of SharePoint. And you saw Elsa reference that she wasn't going to be sending SharePoint links in the future and would be sending meeting materials as attachments. And that's because it's the same principle. If the board members were to, commission members were to edit a document and we could see what edits were being done by the other commission members in a SharePoint, that does unfortunately raise an issue under the OPMA. And I should have also mentioned at the outset that the OPMA, as you can have already appreciated, I think is not a model of efficient operation, perhaps, but it is a model of transparency. So unfortunately, while technology can be very useful, we do have these constraints that are related to the OPMA that we need to mention. And final action is the collective final decision by the commission. That is always required to take place in an open session, even if the deliberations were in a closed session. So as you raised the point about the executive session, you already saw this in action. The commission went into executive session to deliberate about the appointment of the 5th commissioner, but then that appointment was done in the open session of the commission meeting. So final action is always required to be taken in the open portion of the meeting. So there are regular meetings that are held pursuant to a schedule that is adopted by the board, and no other procedural requirements for regular meetings. There are provisions that are applicable to state public agencies, not applicable here. But there is also the concept of a special meeting. A special meeting is any meeting that's called that is not in compliance or pursuant to a regular meeting schedule. That is allowable. The only procedural requirement is that members of the public are notified 24 hours in advance. But the other important principle is that action at a special meeting is limited to the matters that are on the agenda. So if we are in a special meeting, then the commission can't simply amend the agenda to add another topic as it could in a regular meeting. Just something to point out if the board is or the commission is meeting in a special meeting context. Public attendance. The commission or other board can't place conditions on public attendance, although reasonable rules of conduct can be set. We follow the advice of the AGO there that the AG's office that cameras and tape recorders should be permitted unless they are actually disruptive. And I would say, as you may have noticed, all of these conditions are really anticipate or contemplate the actual physical attendance of members of the public. We have been for a year and a half now for all boards and commissions operating remotely. That is because we have a special proclamation by the governor that has authorized these remote meetings. At some point, that proclamation will no longer be in existence, and there will be a requirement for a physical location for the meeting. But for the probably foreseeable future, we will still be authorized to conduct remote meetings. Other important principle from this slide is that there is no public comment required under the OPMA, no public comment period for members of the public required. But I would just note that when it is provided that then the First Amendment comes into play and a wide range of comments must be accepted, including comments that are critical of the commission's work, very high standard for what must be allowed during any public comment period if it is offered to members of the public. And so here is the slide on executive session. So again, this would apply to the full board. We're not talking about a subcommittee or fewer than a majority or a quorum, but this would apply when the full board or commission is meeting. And there are provisions in the OPMA that allow a closed meeting not open to the public, but the topics are specifically listed in the OPMA. And here we have just some illustrative examples. Obviously, many of these are not going to be applicable to the Redistricting Commission, but just to give you a sense of what topics are authorized for executive session, we include this slide, consideration of a real estate transaction when you're discussing the minimum price that a piece of property will be offered for sale. You can understand the rationale there. And then you also see evaluate the qualifications of an applicant for public employment. So that was the justification that we were operating under when considering the appointment of the 5th commissioner. So as long as it's one of these topics, an executive session is justified. And the discussion, though, needs to be limited to the topic. And that is often a potential issue. And you may see at city council meetings, we always have what's called a legal monitor. That's one of us from our section that ensures that the council, for example, if it is going into executive session to discuss legal advice, that is where the discussion stays centered and the council doesn't begin a discussion of policy, for example, in an executive session. Keep it focused on that that specific justification for an executive session. So penalties for violating the OPMA, there are fairly significant penalties. Court can impose civil penalties against each individual member for a knowing violation, and that is not something that is commonly assessed. In fact, we can't point to a reported case that has addressed the imposition of civil penalties, but we have seen that at issue in OPMA litigation in the past, and it is something to note. But as long as you are, again, that's for a knowing violation. So as long as you receive training and make a good faith effort to operate within the guidance, pursuant to the guidance of the training that's provided, then that would not be a knowing violation that would trigger these civil penalties in the first place. Court could award attorney's fees, but probably the most drastic sanction or legally significant potential penalty is that any action taken at a meeting in violation of the OPMA can be declared null and void. That's a fairly drastic sanction, but it is a provision in the OPMA, and we have certainly seen OPMA litigants file suit against the city seeking to nullify action of the council for one in the past. So that's the most significant and again drastic sanction from a legal perspective that is potentially applicable. And so then this slide just covers some of the reference materials. I don't recall whether we put this in your board packet, but if not, we'll distribute these. These are very good shorthand reference practice tips that are put together by MRSC, the Municipal Research Services Center, to guide boards and commissions in compliance with the OPMA. It basically summarizes what I've discussed today. So we will distribute those for future reference, but we will remain available and to guide the commission as it does its business, answer any OPMA questions as we go forward. So I believe that is my last slide. So as long as I can get out of sharing my screen. So any questions or anything that comes to mind that, yeah, sure, Mayor Nichols.
Thank you. Thank you. That was a very succinct view of the Open Public Meetings Act. I appreciate that. I wanted to clarify. Given the size of this commission, anytime three of us have a conversation, that is considered a meeting and needs to be noticed and open to the public, correct?
That is correct, Mayor Nichols. Yes, that would be a quorum majority of this particular commission. Yes.
So outside of that, the only conversations that can take place among commissioners are one-on-one.
Correct. And one-on-one conversations are fine. The only cautionary note there is that there is this concept of a rolling quorum, where if you were to contact Commissioner A and say, I think we should do this, should I talk to the other commissioners? Yes, you have my agreement. And then you were to go and talk to Commissioners B and C and try to come to a collective agreement amongst the majority outside of an open meeting, then that could raise an issue with the concept of a rolling quorum. But in general, one-on-one communications are fine.
Okay, I would like to not hear, but hear more about the idea of a rolling quorum, because it does seem to me that one-on-one conversations at different points during our process are going to be necessary, and they would not just be one commissioner talking to another commissioner, but one commissioner talking to 1, 2, 3 others, or multiple conversations in order to be able to come to consensus in our view of whatever the decision might be.
Sure. Happy to discuss that in more detail. I think but I do have a couple of minutes here in this segment. I would just say that I think it's just keep in mind, it's the concept of trying to come to a collective decision outside. So no problem with you actually going to the other commissioners and saying, what do you think of this? It's really when you say, what do you think of this? I'm going to go to the other commissioners and try to secure their agreement with this outside of the open public meeting. Does that make sense?
It's a pretty fine
It's a fine line. Yeah.
again, I'd like to see some more, if there's any case law on it or rulings in the past that tell you where that line actually is, because as I described a couple meetings ago, for a legislative body at least, those conversations are absolutely necessary for the functioning of effective legislating. So it seems to me we may run into that as well if we have proposals that you know, are very, very different. We're going to have to figure out how to come to some kind of understanding where our colleagues are in order to be able to accommodate their concerns.
Yeah, sure, understood. I'll see if I can find any other specific guidance or anything that sort of clarifies that principle, but I understand your concern, and it is something that is very much an issue. And yes, I would say that the Washington State Legislature has exempted itself from the open public.
Yes, that's always been an irritation to many of us. Yeah. Thank you.
Sure, welcome. Yes.
Yes, thank you, Gary, for a great presentation. Just clarifying points on the special meeting piece, where we have to focus on the business agenda, and then how that correlates with the public attendance piece, where we are not really prescribing to the public attendance in terms of what they can speak to in a special business meeting. How do we sort of thread that line with balancing what comes out of public comment and how we get to focus on just the business agenda? Or does the public comment really not impact the compliance to the OPMA?
Very good question. I didn't want to get too much into the First Amendment principles that apply to public comment, just as a matter of timeliness. We can certainly discuss that more in a different setting if time allows. But there is a limitation, or a justifiable limitation, for public comment to be directed to matters on the agenda. So while there is a fairly high bar as to what comments must be allowed during that public comment period, one restriction that the courts have upheld is that comments must be directed to matters on the agenda. So to the extent that a person providing public comment wasn't speaking to the agenda, they could be limited or asked to redirect their comments, or asked to told that their public comment period is ending if they are not going to direct their comments to matters on the agenda. Does that answer your question? And I think, generally it doesn't require much to adopt a regular meeting schedule. So I think as long as the commission adopts a schedule for the foreseeable future, that would be considered a regular meeting schedule, and we wouldn't consider those special meetings. This is really applicable when you're meeting on short notice and outside of that regular meeting schedule.
Is there, as a follow-up question, is there a limit to the usages or the frequency of special meetings? I imagine you cannot do, 30 special meetings in absence of broad meetings.
There's really not. As long as you comply with that 24-hour notice requirement, then you could operate exclusively under special meeting provisions. But again, it's the limitation of matters on the agenda that can be a fairly significant limitation. So I would suggest it's better to operate under a regular meeting schedule. But in answer to your question, no, there's no real limit to the number of special meetings that could be called.
Thank you for that clarification.
Okay, not seeing any other questions. I think we're right on time. If Ariel, you want to take over? If that's next.
Okay, let's see here.
So Ariel is going to talk about the Public Records Act, another pillar of transparency, as you might characterize it.
Yeah,
in Washington.
the other prong. Let's see here. I can get to presentation.
In the upper right, present.
Okay. Let's see. Are you guys seeing this now? Is it looking like it's presenting, or? There we go.
Yeah. And then if you just click on the screen, it advances.
Okay. Yeah. Hi everybody. I'm Ariel Schneider. I'm the other assistant city attorney present at the meeting today. I'm also in government affairs along with Gary. I will also be serving as the main point of contact for legal questions that the Redistricting Commission may have. I'm kind of the legal clearinghouse. So if we need to bring in other legal advice, I'm happy to coordinate that. But you can consider me the first point of contact. And I'm also going to be training you today on the PRA, as well as a little component of that, which is records retention. So the PRA is shorthand for the Public Records Act, which is RCW 42.56. It applies to boards and commissions. It specifically calls out boards and commissions as being subject to the Public Records Act. Even if you are a volunteer, as a member of a board and commission, you are subject to the Public Records Act. So let's start off by defining what is a public record. It is any writing, which is broadly defined. So a writing could be kind of anything cemented in a tangible form. So a writing includes video, it includes any kind of recording, pictures, photographs, email, share drives, that sort of thing, containing information relating to the conduct of government or the performance of any governmental propriety function prepared, owned, used, or retained by any state or local agency, including the Redistricting Commission, regardless of its physical form or characteristics. So a big question we often get is, what about records that are on personal devices? Do they count? Yes, if the record was created in the scope of your business on the commission, in the scope of your commission work, it will be considered a public record. So briefly, what are your responsibilities as commissioners? So you're responsible for creating and managing records necessary to your work for the city. You're responsible to basically maintain those records. So don't destroy them unless it's in accordance with an improved records retention schedule. And I'll briefly mention a little bit more about that. You're responsible for keeping your records organized so that you can find them easily. You're responsible for retaining them in an accessible format. So you're also responsible for ensuring that final versions are transferred to ELSA, the board liaison, as soon as possible. And once your term ends, you're responsible for removing the board records from your personal computer. So let's talk about records retention really briefly. Records can't be disposed without identifying what their retention schedule is. And that depends on the content of the record. And the city develops multiple different records retention schedules, depending on what the record is. But I thought I'd briefly go over kind of the more common items that the board will be using and just briefly talk about them as an example. So records of commission meetings like the one that we're in right now, which include any kind of records, the meeting minutes, the agendas, that sort of thing. For example, that will have a retention period of 60 years after the meeting. So the final version of those records is going to be retained by the board liaison. So if a commissioner is the one taking the meeting minutes for some reason, make sure that you forward those to Elsa and then delete your copy so that she has the final version. So again, you can keep copies on your own computer, but make sure that once they're forwarded to Elsa or whoever else is acting as the board liaison, that you go ahead and delete them from your own. The one note about email, the retention depends on the content of the email. So that said, your seattle.gov email addresses auto-delete after 90 days. So what do we do about that? Number one, the best practice is always CC, if you're sending out an email, CC Elsa. So that way DON kind of is able to keep track and maintain copies. But also preserve your non-transitory emails in your 7-year projects folder, which should be on the left margin of your email. If you don't have a 7-year projects folder, you can't find it, let me know and we can help coordinate to make sure that you all have one. As the title suggests, it's preserved for 7 years. So that is your best bet. Let's go into what non-transitory versus transitory means. Transitory records are records that don't have a retention value to the city. There's not really anything to be gained by keeping them. Assume that most records involving city business are not transitory. But if it's, for example, if it's a duplicate, if it's a personal email on your city email saying, hey, want to go to lunch, that sort of thing, or happy birthday. If it's kind of a broader publication that gets forwarded to you, if it's advertising that gets forwarded to you, unsolicited, those are kind of examples of transitory records. You know, city broadcast emails, you know, talking about a snow advisory or something like that. That would be an example of transitory record. So they're still considered public records. It's just that the retention on them is different, and so you don't have to retain those. But when in doubt, ask. When in doubt, assume it's not transitory. If you really have a hunch it's transitory and it's not crystal clear, go ahead and ask me. So,
Ariel, so what about, like, so far we have like a whole bunch of scheduling emails. Is that considered something you need to keep? Because what I'm hearing is that we should really take everything and move it into the other folder.
you know what? Let me get back to you on that. I can go ahead and check with Jenny Winkler, our records management person. I'll go ahead and get back to you about that in the meeting. I'll have Elsa forward it to you.
Okay.
Great. Okay.
Just as a very quick follow-up, the 90-day auto deletion rule, is that something that we can change in our own settings, or is that something that you guys?
No, that's operated by the city. So so beware, because if you don't want to wake up 3 months from now and find that email that you were looking forward to and that you thought you had preserved isn't preserved, it just automatically drops off.
Okay, thank you.
So unless you click and drag it into that 7 years folder, it will automatically drop off after 3 months. So the other prong that you're responsible for is responding and helping the public disclosure liaison respond to public disclosure requests. So those are requests that are made pursuant to the Public Records Act 42.56. And that's when a member of the public or a member of the media or some other body is requesting records. There are certain things that need to happen. A big one is needing to respond to a public disclosure request in 5 days. So usually in an ideal scenario, a requester makes a public disclosure request through the city's public disclosure portal. And that goes straight to the public disclosure liaison and they will go ahead and contact you. However, we don't live in a perfect world. And sometimes for whatever reason, you may find yourself being contacted personally with a request for a record. If that's the case, forward it on to the public disclosure liaison, the public disclosure officer, as quickly as you can so that they can make that 5-day deadline. Elsa, I have a question. Have we, who is the public disclosure officer for DUN?
That is either Jean Murphy or Patty Camacho.
Okay, Patty Camacho is the one I'm used to dealing with.
Yeah.
So basically what you can do is go ahead, ring the alarm if you get such a request, and we'll make sure that it gets forwarded on. So I want the rest of this slideshow when it comes to the public disclosure requests has, I kind of want to just set expectations about what's going to happen to your records in the course of a public records request. So you may be contacted by Patty or by a different PDO. And if you receive a public disclosure request or a discovery request, if there's litigation, you have to turn over your records, even if they're on your personal computer or if they're on a share file. And even if they technically are past their retention schedule. So for example, if you're holding on to something longer than it needs to be held on to, you still have to submit it for a public disclosure request. So, you know, if you haven't deleted those transitory emails and there's a public disclosure request for them, those are going to go in. Let's see here. Let's talk briefly about some exemptions. You are not going to be responsible for applying redactions to your own records for exempt material, exempt language. That is the job of the public disclosure officer. So I just want to briefly touch on a couple of common exemptions just so you're aware of them, but it's not your job to assert them. You can always ask questions about whether they would apply or raise your concerns that some of them would apply. But the ultimate decision is with the public disclosure officer about whether those exemptions apply. The same thing, and I don't have a slide for this, the same thing goes with whether a record is responsive or not. Your responsibility is to help the public disclosure officer obtain all potentially responsive records to a request. But ultimately, it's their decision about whether a record is responsive to the request or not. So with that said, let's touch on a couple of exemptions. There are a lot of exemptions to public disclosure under the PRA, and oftentimes they're very specific. Exemptions are always to be interpreted narrowly, so the tie goes to the requester. When a record contains both exempt and non-exempt information, we redact instead of withhold. So whenever we are redacting or withholding for an exemption, we create an exemption log where we explain the statute providing the exemption and explain how whatever we are redacting or withholding is relevant to that exemption. So you can't silently withhold a record. So again, if a PDO, that's shorthand for a public disclosure officer, is contacting you for records, it is no bueno to just make a determination in your own head that such a record is exempt or isn't responsive and just not produce it without explaining anything to the PDO. What you should do, if you're really concerned about an exemption applying, is produce it to the public disclosure officer with a bit of an explanation about why you think it's exempt, but then go ahead, it's their job to actually make the determination. So again, a department's PDO needs to have all responsive records in order to make an exemption determination. So you just got to leave it, your job is to cast a wide net. And if you're really concerned, let the PDO know, but the PDO is the one that's going to be making the ultimate decision about whether something's exempt or not, or whether something's responsive or not. So briefly, some common exemptions that will apply to, that will potentially apply to your records. There's attorney-client privilege. So that's if I'm being asked or Gary's being asked something, a legal question, we're providing privileged advice that can be withheld as exempt or redacted as exempt. The commission owns the privilege. So if the commission decides to waive attorney-client privilege, and that's a decision that you make as a body, we can go into that, but that is an option. So we can talk about that at a later point if it comes up. Another exemption that you might run into is deliberative process. And so without going into it too much, I'll just go ahead and describe the statute mentioning deliberative process. So it's preliminary drafts, notes, or recommendations, intra-agency memorandums in which opinions are expressed or policies formulated or recommended. They're exempt, except that a specific record is not exempt when publicly cited by an agency. So your opinions or analysis about an item that's being deliberated might be exempt under this exemption. This exemption, though, expires once a decision has been made, so it's not going to be exempt in perpetuity. Underlying facts are not exempt under this exemption. So if you're basing your opinion off of certain data, that data is not exempt, but your analysis or your opinion might be. Other exemptions are certain personal contact information from your personnel file or a call list. Again, it depends. So if you have concerns about that, go ahead and talk to the public disclosure officer, or go ahead and reach out to me. It's important to note that there is no blanket right to privacy under the Public Disclosure Act. So just withholding something just for the sake of privacy, that doesn't fly under the PRA. It has to be tied to something else. So speaking briefly about consequences for noncompliance, liability, the commission will face the liability. It could be up to 100 days per record, plus attorney's fees and costs. There are certain frequent flyers who love finding instances of PRA violations and will sue on it. Similarly with the records retention, there will be liability. And the other consequences is that there's a loss of public trust, a loss of legitimacy and transparency, and some headaches, distraction from the core mission of your commission's work. You guys do not need more work thrown on your plate than the core work of redistricting. So making sure that you are thoroughly and swiftly complying with the Public Records Act and records retention actually saves you time and work in the long run. So any further questions, I'm happy to answer them here. You can always also reach out via ELSA, or just go ahead and email me, and I can either answer your question or direct you to your question. For example, roping in records management, Jenny Winkler, who is the guru of all records management questions. And if you'd like more training on that, I can also bring her in. And that's it.
Thank you, Ariel. I had a question. If only one commissioner or two want to have more training, is that possible? That somebody's interested, or do they all have to take if they want to hear more or get more training specifics on this training?
Oh, happy to do individually. That I don't see a problem with that. Do you?
Sure, absolutely. That would be helpful. Mm-hmm.
Great, thank you. Well, thank you. Now I'm sure you guys were all checking your emails, making sure you know where those are, and we are happy to troubleshoot with the way that you see your emails too. So if you need like specific sessions where we can do one-on-one sharing screens and going over that, we're happy to facilitate that for you, because I know it is nerve-wracking when you don't know, when it's a different system. And so please reach out.
I'm signing up because I don't see anything that says 7 years on mine.
Same.
You're not? Okay. All right. Let's also let's you and I coordinate about getting IT to set that up.
Yep. Got it.
I also don't have that folder, so
Okay.
it looks like two of us.
I'll assume the commission doesn't have it yet. We'll set it up for you. So
as we were being appointed and organized into a commission, Elsa, we exchanged emails. The fact that you have those emails satisfies. I don't need to retain those because they're on the city system. And whether they need to be retained or not will be a judgment that you and the public disclosure officer will make. Yes?
Ariel?
Well, so let me understand your question a little bit better. So are you talking about the emails exchanged before you were appointed as a commissioner, or before, I'll broaden it, before the commission was formed? Is that what you mean?
As the commission was being formed, we had lots of emails about meeting times, as I think was mentioned earlier, agendas.
Okay, and were these, is the question whether you can delete them from your personal account?
Well, yes, if the liaison has them, since
I see. So if she's on the answer is no. You're responsible for retaining your own emails, whether or not Elsa is on those emails.
Huh, okay.
And I guess the question too, because they were sent to like their personal emails before they had, city emails and all of that.
Right. So that goes back to the bit, and we can go into this a little bit further. That connects to the point about you are responsible for retaining the records that are on your personal devices. That includes personal email addresses if they're involving city business.
One thing what they could do is send those emails to their city.
Yes, that is, that is actually
Address.
something that we recommend. If you have information from your personal email, go ahead and forward it to your city email. You can mark it city business or commission business. And then once it's in your city email account, go ahead and delete it from your personal account. That's a
Okay.
great solution.
Great, thank you.
Protocol, once we have that 7-year folder set up, like every month or every week or something, just move everything in there?
Unless it's transitory, yes.
Because it sounds like if it's, well, so far anyway, unless it was all the agenda stuff, which you'll let us know.
Yeah, I'm going to back to you on that one because I want to make sure that you don't have to keep it longer than you need to.
And just as a warning, you don't get a warning that the 3 months passed. They
do
just
not.
go.
You
That
do
for
not.
Oh,
Yeah, it can be surprising if you go back and all of a sudden say, "Hey, what happened to all my June emails?" So just be aware of that.
Basically, you just need a system of just pushing it all into that. And there's no limit on how many emails can sit in that 7-year folder. So
Yeah, within the 7-year folder, you can create subfolders for your own organizational purposes, you know, so you can make sure that they're all organized that way. You don't have to, but you can just by right clicking and creating some subfolders.
that must be a searchable folder as well. So if you're looking for something.
Yes, they are. Yeah, you can search an outlet for that. Yeah.
so you all are going to figure out how to create those, how each of us can create those
Yes, yeah,
repositories.
we'll get back to you on that.
Great, thank you.
Well, great. Now we need to take a break and then, okay, we'll get this organized and done. And now I won't be getting that many emails from all of you. Now I know. So shall we move to the next piece of the agenda, which will be basically decision-making points, and I will just list them, and then you will we will work on a way in which how we're going to go about them, and just want to confirm that you all got documents that you have access to, including bylaw materials or were in the handbook, structure suggestions that staff put together in that handbook, and the district master RFQ. Just as a preempt, like everything, this is what staff, the IDT, the interdepartmental team for redistricting work put together for you as a guidance to start with. You can change it, you can add it, you can make as many additions or edits as it needs. It's starting point for it. But we did research on other commissions and other processes. We also, of course, based it on the charter and the information there. It's something we can use to start the conversation. So having said so, if it's okay, we will move to the approval of bylaws if you got a chance to look at them.
Just to clarify, the bylaws are in the handbook?
Yes.
All right, let me
And
just a minute to
I'm
pull
gonna
that up.
I'm gonna share my screen to point them in that direction. Let me see if I can do this. Can you see my the handbook? Okay. So just a little quick review on this. It should be on part of the appendix, page 12, 6 to 17, which basically will talk about the name, the mission statement, the membership, and the commission chair, and all of these rules up until point number 6. And I think we can start with some and make additions. That's a question I have for Ariel of how much of this do we need to approve today? But if you have questions or comments on the process, this is the good time.
In terms of how much you need to approve today, I mean, it's up to the commission.
So obviously we've made suggestions like the redistricting commission. The mission statement is stated in the charter there, but this is what we have, and the membership, which should have all the details here. They're all suggested for you.
So I don't see any huge things that stand out for me as an objection. However, I do want to build out, or I want to suggest that we as a commission come back to this in perhaps a few months after we've gotten a little bit more of our business under us to reevaluate this. Given that we are the first commission to take on this work, I think that this is a good framework for us to start and operate under, but I do want to give us the moment of creativity and reflection to put in a more forward-looking set of bylaws. So am I correct in asking that you're looking for a motion to approve these bylaws? Okay.
That's
So
right.
I'll put out a motion to approve and adopt these bylaws for the Redistricting Commission.
Second. That.
Great. Thank
Mayor
you.
Nichols?
A question. In a previous meeting, we had talked about public comment, and it was referred to by legal counsel. It is not required, but if you do provide it, there are restrictions. Well, there are restrictions on the commission restricting that public comment. Is there anything in here that requires us to have public comment at every meeting? I thought that was something that was mentioned earlier, but I don't see it.
I'm looking at it, but we have included as in the spirit of every time we have a meeting to have space for people to do that. So in the website right now, if people are interested in participating, they can sign up ahead of time. And thank you for bringing it up, because this time we didn't have anybody, and you know, it's part of like this outreach and work that we have to do to make sure that people know that that's that possibility and all of that. So there's an option for people to do it ahead of time, but in this, I need to find it to see. I don't think there is anything there about having one.
Okay. I think it's great that we have that option. I think it would be a mistake to make it mandatory. If we have this kind of a constraint on how much time we have together as commissioners, and someone wanted to disrupt our ability to do our job, they could do it through a concentrated effort to flood the public comment. Not saying anyone's planning on doing that or likely to do it. I just think we should have the tool to be able to say whether or not we think that there should be comment, or the chair and the liaison and putting the agenda together should be able to make that judgment case by case.
So I might suggest that we table a decision on the initial bylaw, unless there's some need for an immediate set of bylaws. If we table this to the next meeting to make sure that everybody's had an opportunity to really go through it in detail, would there be any problem with tabling adoption of the bylaws until the next meeting? I mean,
Is that a question for me?
yeah.
No, there's no statutory requirement that the bylaws have to be approved at this meeting.
EJ, you're the one who moved for adoption. Do you have thoughts on maybe tabling this until the next meeting?
I think you're muted.
God, sorry. It was profound, everyone. Very profound. I said no. I think that's fine. Nalima had a second on the floor, and I think if she's amenable to it as well, I have no problem
That's fine.
holding.
While we're looking at it, though, there's one other. I know we're going to get to the RFP, but the timeline on here says November 15, 2022 for the end date, and other materials say December. So it seems like that should be the same.
So do we need to have a vote on tabling this, or what's the process?
Not if the maker and second both agree to withdraw at this point.
So withdrawn.
All right. So yeah, Elsa, maybe we can move on to the next.
Great. So our next item is on the structure of the meeting of the commission, which is electing a chair. Is that right? Let me pull up the agenda right here. Yeah, chair selection, which I was going to say there's a proposal also in the handbook on how to get to that process, but I'm going to share it with you right now. So I guess the next one is selecting a chair for the commission. And it has to do with selecting a chair in terms of how do we select it, and also how long, and if there is, how long would this person be a chair, and how will it change again if it has to, if it's not for the whole time, or if it's every 3 months, or if it's however you decide it.
Is that section 4?
Oh yes. Would it be helpful if I continue to share the handbook or the agenda?
I think the handbook will be
Okay.
helpful.
I'm going to stop sharing this.
I do have a question on the procedures and how they do align with the selection of the chair, because they are included under the procedures document, and does that inform the process of chair selection?
Mm-hmm. So your question is if how not adopting the bylaws today affects the selection of the chair?
That's my question here.
Mm-hmm. And Ariel, do you have an answer?
Yeah, I mean, if the bylaws aren't adopted, you're not bound by them. So I think you could probably consider it to be a recommended procedure. Looking at the charter, it does not mandate a certain procedure for selecting the chair. It just mandates that a chair is selected. So without the bylaws being adopted by the commission, the ball's in your court for figuring out how to adopt the chair.
Thank you for that clarity.
I would suggest majority vote would pretty well satisfy any potential bylaw.
Yeah.
I'll suggest 3-month rotating position so that it potentially rotates through multiple folks. And if no one else is making nominations, I'll nominate Commissioner Shaw as the first chair.
And I will second.
I don't accept your nomination. I think I'm still getting to know all the systems and everything, so I'd rather pass to somebody else.
Not sure there's a procedure for withdrawing.
I don't know. Yeah. Thank you, though.
All right, Commissioner Malaba, have you served as chair of the Planning Commission? Do you have experience as chair? Maybe you would be a good first chair.
I would like to make a motion to nominate someone else. To nominate Commissioner O'Sullivan as our first chair.
Okay,
Second.
well,
Thank you, Mayor Nichols.
Quick, before he changes his mind. All those in favor?
Aye.
okay.
Aye.
Is there
Okay.
discussion? Rory, would you like him to?
Yeah, I can. I'll be the first chair as long as the rest of the agreement though is that it's only a 3-month position, at which point it will rotate to someone else.
Understood.
Okay, then I accept.
All those in favor?
Aye.
Any opposed? Congratulations, I think.
Yay! Congratulations. Lots of decisions. Great.
That was one way of doing it, right?
Thank you for that. So I guess we have covered 2 decision big points. Now we are moving to the third one, which is the RFQ. Request for quotes or quotation for the district master. And so for that, I also sent an RFQ that the IDT put together. I also sent 2 references for what King County, how they announced their position and hired whoever they hired, as well as the state. At this point, I'd like to make note that I invited members of the IDT to the meeting in case you have questions. And so we have our demographer, Diana Canzoneri over there, our senior GIS from OPCD, from the Office of Planning, and also there, and as well as our senior contract manager at the Department of Neighborhoods. So if we have questions, here they are to help us. And if you have comments or if you don't know where to start. So we have that document. I'm going to try to share it now. And if you have questions and comments, let's start.
Also, if you don't mind, so
Oh, yeah.
I'm just looking at the draft that you have sent around, and it looks
Yeah.
like that draft has my notes, which would be covered by attorney-client privilege. So unless the commission opts to waive attorney-client privilege, I would suggest not doing a screen share in this meeting.
Okay, sounds good. Thank you.
Do we have members of the public on this meeting? Well, regardless, I would recommend not screen sharing.
Yes, we do have public. Yeah.
Okay, so commissioners, feel free to look on your own screens to the email that Elsa sent to you, so that you're able to see the drafts. But let's go ahead and keep those on your own computers and not on the screen.
Thank you for that.
Okay.
So,
Yeah. So one of the, I think, primary questions, and this may be is what we're talking about appropriate as a request for qualifications? Is there somebody who's able to answer that?
can you repeat the question?
So is based on the detail that's included in this document, is it appropriate for it to be a request for qualifications?
This is Jen from Department of Neighborhoods. I actually think, given the amount of detail, this is really more of a request for proposals. Request for qualifications is typically just asking for that, for someone's qualifications for, a CV or a resume, as well as a client list, prior client list. The approach, if you feel that the scope is very clear and you just need to know someone's qualifications, then it's appropriate to do an RFQ. But if it's a little bit more open-ended and you want to understand the approach, how they would approach things, what strategies they might use, then you would look for a request for proposal. One other thing I'm going to put in here, add to this, and I did talk with Elsa, and it sounds like there's some shifting available for the timeline, but the process for an RFP or an RFQ is typically, it's recommended to take at least a month and up to 3 months for a process for folks to be able to submit bids or proposals, for those to be reviewed by a committee, for those selections to occur possibly to include interviews and then to actually go to contract. So the timing is can be pretty extensive, but my understanding, and it's limited right now, but my understanding is that given the amount that we're talking about, that there could also be an option of looking at a consultant roster that exists within the city and choosing directly. It's called a direct selection process. That someone who has those qualifications, but there's still. But I would want to look into more of the detail in terms of whether you make that a competitive process or not. I mean, I think officially you don't have to, but I think that in this instance we want to. So sorry if that's a little bit gray, but there's a couple things I'm not aware of yet to be able to answer completely.
If I could just hop in really quick to talk about timeline, since the commission is now formed. Per the charter, once the commission is formed, it is either by November 30th or 2 months from the commission being appointed, whichever is sooner. In order, the deadline for appointing a districting master. Now, we've interpreted the November 30th date to be 2022. So the timeline we're working with now that the commission has been fully appointed is 2 months from the date of the appointment. So 2 months from the date of the last meeting. That's going to be the timeline to work with. And that's to get the districting master appointed.
And so is it possible to do a request for proposal in that sort of a time frame? Or is that what the thought behind making this a request for qualifications as opposed to a request for proposals?
I believe that there's time to do that for a request for proposal. I think it comes back to what are the functions needed and how important is the approach, and how much do you need to actually learn about the person that you want to hire.
And with a request for proposal, there's a requirement for the notice to be advertised, which is different from a request for qualifications. Is that true?
So RFQs and RFPs are both required to be posted and to be advertised for at least 2 days, at least in the Daily Journal of Commerce, and put on the Consultant Connection, which is a website at the city through the Financial and Administrative Services.
I guess the primary question is there any downside to making this a request for proposals as opposed to a request for qualifications?
In my opinion, the request for proposal gets you a lot more information. I think that the request for qualifications often though happens with when you need something very technical, but also, and anybody else who is experienced with this, please weigh in. But if you have something more technical, and if the scope is very, very clear and you just need someone's qualifications.
I think Mayor Nichols, did you have a question?
Well, it was very similar to what the chair just asked, which is kind of what, for our purposes, what is the distinction between a request for qualifications and a request for proposals? Why do we care?
I think you care because when you're officially asking for a request for proposal, you are inviting the potential contractor to give you a sense of what they propose, how they will go about this work. That leaves some more room, I guess, available for asking specific questions like you would in an application for a particular kind of activity. Whereas a request for qualifications is simply that. It's going to be, give us your resume and list of projects that you've worked on that have been similar to this. So I would say a request for proposal is more forward-looking. Request for qualifications ensures that you have the background to do the work. Does that make sense? I mean, we don't, to be honest, there's not they're often used interchangeably, and the rules that the city has are the same in terms of what you use, in terms of when it has to be advertised, the timelines, those kinds of things. There's no difference between those two.
Yeah, so what, so are we considering simply adopting the document that has been proposed, or adopting it with, you know, reasonable edits? So I think there may have been a date at the end that hadn't yet been updated. Well, and actually, I guess one thing that we need to consider based on Ms. Brandon's input is extending the timeline. It sounds like there's been a recommendation to extend the timeline for to receive proposals and interview individuals past what's currently proposed in the RFQ. So what is the process for, I guess, does anybody have any objection to extending the timeline based on Ms. Brandon's proposal, but within the 2 months from last week? And so are we able to adopt it with suggested changes, or are we expected to adopt a final draft, or what's the process for this?
So there's a couple of things. One is definitely the timeline. We put it there for you to see what would it take for us to get us to November. And I can read them out loud to walk you through that to see.
Well,
That's
yes. So it sounds like it sounds like there's no objection to extending the timeline based on
Yeah.
Ms. Brandon's recommendation. So
Right.
we might want yeah.
You don't, yeah, okay, I get it. We might not want to do that. The other one was, this is what we propose. That's the qualifications. If you have questions, technical questions on what this person is going to be doing and what is this, and also what type of work are we asking for? And if you have questions, we have also, you can ask our technical folks here who can, you know, ask as much as they can at the moment. I think that's the other process I think I'm offering.
Well, and so it sounds like there's been a recommendation to title this, like not necessarily significantly change the content, but change the title to a request for proposal, just so it's clear to potential applicants. Is there any objection to that change? I haven't heard an objection to that change. And so obviously one thing that we're dealing with is a very tight timeline. As Ms. Brandon indicated, these are normally take 3 or more months. We have less than 2 months based on our charter requirements. So I think we probably want to move forward with a decision today. How exactly I think the timeline is going to be a little bit complicated, because if we measured the timeline out exactly 2 months from our last meeting, we'd be getting right up to almost up to holiday. But Commissioner Shaw?
I'm looking at the timeline. It seems like that what's on the table is providing a little bit more time for the applications once this is posted. It's maybe, you know, closer to, you know, 3 or 4 weeks on that end. It says timeline, and then it says November 12th, 2021. Applications must be received or postmarked by October 28th at 5 p.m.
Oh, that was a typo from all the times that we had to move that. Yeah, that's definitely a typo.
So the due date would be November 12th.
That's right.
Currently proposed. So that's what maybe
Yeah.
we're considering. I mean, obviously it pushes everything back, but I think that's, you know, you work with that and then you push things back accordingly.
And so this might be a question for Ariel, or can we approve sort of the RFP as outlined with an expectation that staff will update some of the specifics, or do we have to, like, as a commission, approve a final document? I think you're on mute.
Sorry. I would approve, I would recommend approving a final document. I think that's going to be important for you guys to look over.
So is that something, if we give staff direction based on our meeting today, can we ask staff to provide a draft based on our recommendations tomorrow that we can approve over email?
That then
Be
raises
approving that you're going to need to have an open meeting for that.
Can
Yeah,
I suggest that we authorize staff to move forward with issuing a request for qualifications or proposals based on the document that has been presented to us?
I mean, it doesn't sound like we have substantive changes other than extending the deadline.
So I would just also point out that there are still notes for legal advice that haven't been incorporated yet. So that would need to be incorporated. And I believe there are some other notes as well suggesting changes that haven't been incorporated.
Which would be allowable under the motion as I just made it. Staff would be able to make those changes, and we'd be authorizing them then to put the request out.
Gary, what do you think?
Yeah, I think that's fine. I think as long as it's clear to staff what the order is, what the motion is, and I think if the motion is to approve the RFP with the change to the timeline that has been agreed upon here, and that's clear what that timeline is, in addition to approve the RFP incorporating the comments that are listed on the document, the staff's incorporation of the comments that are listed on the documents, and I think that gets you there. Ariel,
and fixing any typos.
Correct.
Yeah, I guess my only concern is that where the note leaves some options open-ended for what to write in instead of suggested language. I think there are a few notes where they say, where it's calling out that this might be an issue, but it would be up to DON to make decisions about what to write in. And so that's the only area that's giving me a little bit of concern.
Are there multiple areas like that? Can we just cover that?
Let's see. So without revealing too much, for example, if we go into the qualification section, the notes on qualifications,
Yeah.
those are areas where I think there's going to be some decisions about what kind of minimum qualifications there are and how to articulate that.
Okay.
Yeah, and that's an area where I had questions around the racial equity language as well, that it has been kept very broad. And can we be more specific in terms of the competence around racial equity? And beyond that, can we include that additional question in the list of the approach and methodologies, but also have a racial equity section where they can articulate their competence around equity in representation?
Patience, are you suggesting under the scope of work and deliverables that like you move up there's something that talks about racial equity in that section?
Yeah, that's my suggestion. Just having one area where they can articulate their competence under that and how that will be integrated in the process.
Right, because I agree with you. And then under qualifications, the bullet as written now is pretty broad. It would be hard to know if the person met that qualification or not.
And maybe under the scope, it could just be included in the team composition and competencies and just include language around talking about their racial equity.
So I'm going to note that we're only 6 minutes away from the time when we're supposed to conclude, and we haven't yet talked about our next meeting. So it sounds like maybe we're not going to be able to come to a consensus on finalizing the RFP today. Would it make sense for us to at least talk briefly about when our next meeting is in order to decide whether or not we need a special meeting in advance of the next meeting in order to finalize the RFP. So I guess my question, I think we had talked last week about having weekly meetings on Tuesdays. Elsa, were you able to get in touch with folks to find out whether or not everybody is available next Tuesday?
I got a yes from everybody. I don't think I got a response from Commissioner Malaba. So this will be the time to let us know. Everybody else agreed, I think.
Tuesday, what time?
11:45.
Yeah, I think we're right now we're looking at 11:45 to 1:15 meetings.
Yeah, Tuesday is harder on my part, and I apologize that I had not seen that email.
I show it as being held on my calendar on Wednesday, not Tuesday.
Well, yeah, I think during our last meeting, we found
Moved to
out
Tuesday.
that we looked at Wednesdays in November, and each Wednesday in November had at least one commissioner who couldn't make it.
Okay. So Tuesday, the 2nd does not work for at least one commissioner.
Yeah.
Thursday?
Is that an ongoing conflict for you on Tuesdays?
At 11:45. Actually, the meeting that I have, I'm happy to shift one meeting and be there for next Tuesday. Then I can coordinate with you on the other standing dates.
Okay, so again, thinking about the timeline, do we feel like if we finalize an maybe if we're able to provide input over email between now and Tuesday, and then finalize it on Tuesday the 2nd, is that giving us enough time, or do we need a special meeting before next Tuesday in order to finalize that RFP? Do commissioners have thoughts on that, or staff?
Tuesday should be fine.
Yeah.
Yeah,
I feel like oh, go ahead.
Just keeping in mind the OPMA issues that we discussed, we need to avoid discussing and exchanging ideas via email, but it would be okay for commissioners to individually send any suggestions to Elsa and then be prepared on Tuesday with decision points to decide in the open public meeting. So as long as we avoid that collective discussion, just wanted to add that.
So what that would look like is you can send me comments in each document, and then we will compile them and propose all the changes in the meeting. And maybe send you a final document with all compiled at once. I don't know, maybe we can't send that email, but present that at that meeting for your approval.
Okay.
So we just as clarification, we won't be able to review the final version before the meeting.
That's my question, because I think we can, right? Like they can send me all individual ones, then I compile them, you review them, and then we just come to the meeting for all of you to decide. Is that correct, Gary?
That's probably okay if you're not, if it's not clear which individual commissioners suggested the changes.
Okay.
Okay.
We just need to make sure that collective decision is in the open meeting next week.
Got it.
As staff to support this, I guess I'd like to lift up a couple things. I think the minimum qualifications issue is really key. So folks who have thoughts about that, please concentrate on that, as well as the Appendix B, I think, is the application. It's just starter question, but if there's a more specific or pointed way, and to include a question about racial justice and racial equity issues, competence, approach, that would be added there, so that's where you would actually be collecting information from the people. The third thing to look at is timeline, in terms of how long you think that you want to give people to prepare this proposal and submit it, and how long you want to give yourselves or a subcommittee of you yourselves to review and then decide, deliberate and decide on who to offer the contract to.
So recognizing that this meeting is scheduled to end at 1:15, maybe we can table the passage of the meeting minutes from previous meetings until the next meeting. Acknowledge that the next meeting is going to be focused on finalizing the RFP. There's another item on the agenda, which is Q&A, but I don't think there was anything else. Was there anything else substantive that we needed to cover today, Elsa?
No, I don't think so.
Commissioner Shaw?
I might suggest also that we send out another doodle, because I've been holding both the Tuesdays and Wednesdays, and it's getting pretty hard to reserve both slots going forward. So if Tuesdays are not going to work going forward and we need to start over, and we may need to, try other time, even though we've been trying to hold this time period.
Yeah, I guess my recommendation would be let's keep Tuesdays. I think we've determined that there's at least one commissioner who's not available on every Wednesday in November. So let's keep Tuesdays, and then we'll determine whether Tuesdays work at the next meeting.
Okay.
But to keep us on track, if there's nothing else that's super pressing, I think we should adjourn. Is there anything else that we need to cover today, Elsa or Ariel?
No, just that I will check in with you, Chair, for the next agenda, to propose the next agenda, and we will send it to everyone. So.
All right. Well, thank you for all your work. Thank you to Ms. Brandon for all your suggestions, and to Ariel and Gary for those presentations.
Right. See you all Tuesday.
All right. See you on Tuesday.
Don't forget to vote.